Yeah, or what? Wow. So what are they like Japanese and stuff?
You can't run me up like that.
Good morning. Can I have everyone take a seat, please? I would like to call our poets, Pastor Shuford, I am Zion, pastor of this church. Please come up and lead us in prayer.
Good morning, let us pray. Oh Lord, we are most grateful for every day that you give us, and for the opportunities to learn, to be better, and to make life better for others. As always, we invite you to be a total part of what we do in every day. So, at the beginning of this clinic, we welcome your presence and your guidance. And we thank you, O God, for those who will present and offer information for our good and for the good of our family members, our community, our city, humankind. As always, thank you for leaders who are putting back into the community and into the citizenship, even as we call ourselves a community. So bless the efforts today as we offer them in the name of your Son, Jesus, who is also the Christ. Amen.
Thank you, Pastor. My name is Deborah Neal, and I operate a little consulting business that puts on these events for nonprofits and churches and other organizations. I think it's important that we provide information to help educate our communities about these issues that we're going to be addressing today. I want to first of all acknowledge our hosts and thank you so much for opening your doors for this, as well as the presenters you're about to hear today, and all of our co-sponsors that you can see on the flyer that is at the table. The way this is going to happen is we're going to have presentations, as you see on the agenda, and then there's going to be a Q&A after each presenter, and for about 15 minutes. At 11:30, we're going to break for lunch. I think that you know where the bathrooms are. If you don't, someone in the back will let you know where those are. I also bring you greetings from other co-sponsors, including Councilwomen Riley and Johnson, who help underwrite the cost of the meals that you're having today. With that, I'm going to ask that Corsica Wade come up and also bring greetings.
Good morning, everyone. My name is Corsica Wade, and I partner with Ms. Neal as a member of the Maggie Street Community Development Council. I'm the secretary for that organization, and also I am a consultant for Woodman Life during my regular 9 to 5, but I'm really pleased to be able to be a part of the work that Maggie Street Community Development Council does, because we're able to work in these kinds of areas and possibly be able to help our people in the community. And on behalf of my organization, as well as Ms. Neal, I would like to just say welcome and thank you all for being here today.
Thank you. Ms. Wade has recently joined the board of directors for Maggie Street Community Development Corporation, who just kicked off a critical home repair program, and she's one of our younger members who's stepped up to be a leader in that organization and is also one of our co-sponsors. It gives me great pleasure and it's an honor to introduce to you Montgomery County Probate Judge J.C. Love III. Judge Love has been a wonderful supporter of these events, imparting so much information about probate court, probate procedures, the things that you can and can't get accomplished there. And it's always an honor for him to come and take time from his schedule to be with us. Thank you so much for you, Judge Love. Let's give him a hand.
Good morning. You know, it was definitely a good feeling when I pulled up and saw so many cars parked around back, and knowing that we'd have a good crowd turning out here today to really get some good information. And I hope that we have a lot of people who are tuning in online, because this is definitely something that we all are going to have to face with and deal with at some point in time, whether it be dealing with it with our parents, our siblings, our children, or even ourselves. And for many of us, speaking about, death and doing power of attorneys and advanced healthcare directives is very taboo, because it forces us to put ourselves in a very vulnerable situation. And we've got to put ourselves in the mindset of thinking about what do we want to happen when we're not going to be here and see the sun come up tomorrow. Or if we're in a situation and we can't be able to make decisions for ourselves, what do we really want to happen? And it's one thing to say it kind of in jest around family and friends at events, but it's another thing to really sit down and really think critically about what you want to happen in those moments. And so I'm thankful for Reverend Shuford for opening up the doors to Mount Zion. This is my home church, and so I'm always grateful to be back here, really grateful for him to really saying that this is something worthy and desiring to really go ahead and make available to the community, but also Professor Kraft here with Faulkner and what they have done with the Elder Law Clinic to be able to help members of the public be able to get legal services to deal with the wills and the power of attorneys and filing those administrations, but also dealing with issues of heir property and how to navigate those issues, because at some point in time, if you don't already, you're probably going to be a co-owner of some heir property, whether it be you've inherited from your parents or it's passed down from your parents to your grandparents. or, or even with your spouse. But it's something, and this is all things that, can get very complicated, but being able to have Faulkner as a resource to be able to help the public be able to navigate those things are really a great bonus, as well as Maggie Street and the other partners here, to really thinking that this is information that we all need to know. But like I said, when we talked about in the probate court, for those who don't know me, my name is J.C. Love, and I am the probate judge here for Montgomery County. I'm a Montgomery native, born and raised. My wife, her grandfather here went to Mount Zion, and she's a local dermatologist, and we have 3 young kids, Caroline, Catherine, and James, 9, 8, and 6. So in a couple of weeks, they'll be 9, 8, and 7. So, thank you all for coming. And so what we're going to talk about, really, they pull back up the screen and really say some of the things that we really deal with at the probate court, the wills, and that's when you left a written instrument saying what you want to happen to your assets when you pass on, as well as the administration. And the things that I tell you are much like anything in life. The more proactive you are, the cheaper it is financially, particularly when you're looking at, will, administration, power of attorney versus having to come to the court for conservatorship or guardianship. And so having these documents in place really keeps down a lot of the acrimony that I see, that some of the most bitter fights we have are really in the administration context. You may have heard those situations with family and friends, and you may have been involved in it, where a parent has died, and sometimes it's a race to who made it to the house first. That someone gets there and they done change the locks on the doors and they won't let y'all in, or you may have been told that a certain family member or grandparent or parent used to stash a lot of money in the house, and someone makes it there first to lock you out, and then no one knows where the money is. But one of these things that I always often tell the litigants when they come before me, particularly siblings when they're fighting, and even sometimes when you've got parents in some situations having to testify against your kids, that I know that your loved one didn't expect that you'd be sitting here fighting over things they left behind. Many of us, when we talk about, doing these documents, I talk to people about having wills, and do you have them? And a lot of people say, well, I don't have anything to fight over. I've got this old house, car, TV, ain't really much for people to fight over. But throughout our lives, there have been a lot of things that we've accumulated that may not have monetary value, but also have sentimental value. And often, as I tell women, that you may have a granddaughter, and you may say that I'm going to give you this ring or this necklace. This is going to be your jewelry that I want you to have, and I'm going to put it in this drawer for you. And so when I pass on, you come to the house and get that ring and that necklace or that jewelry out. And that person may pass on, and that child comes to try to go to that drawer and get it, and an aunt or another family member says, "What are you doing?" And say, "Grandma told me this was my ring." And say, "Well, she didn't tell me that, and so you're gonna put that on back." And so when doing these things in the will, it's not really that complicated. Like I said, it's really just a written instrument for you to go ahead and decide what do you want to have when you pass on. And so when we talk about those sentimental things, they're things I tell people, if you only got one thing and more than one child, then the fights that can happen over things. And so you often find sometimes when a parent has passed on, and one child is kind of trying to take the lead to kind of go ahead and step up, that you find some friction up there in the family that really comes out of childhood. That we all, if you have more than one child, believe that we're loving them the same, treating them the same, but they don't always feel that. And so sometimes in these situations, it comes out that, JC was always mama's favorite, and now he's trying to control things, and he ain't gonna tell me what to do this time. And so the more and more that you can do to really go ahead and take that pressure and that emotion out of the situation, the better things will work for you. And so with the will, I'll tell you that the law has really made it very, very easy for you to create a written instrument. And there have been case laws out there where the Supreme Court has said if someone has gone through the effort to leave what they believe to be a last will and testament, then the court should try to find every effort possible to try to uphold it. But here, really, in just, most of the wills that we have are, self-proving wills, and that's something that Mr. Kraft will get into a little bit later, and that just comes with a statement at the beginning saying that you're over the age of 21, entering it freely and voluntarily and of your own free will. But all wills in Alabama are required to have your signature on it, and as I told you, what our Supreme Court says is your signature does not even have to be where you're supposed to sign, as long as it's somewhere on that document. So across the page, down the page, at the bottom of the page, up the side of the margins, that should be upheld as a valid will. And you have to have 2 witness signatures. So 2 people who witnessed you go and sign that document. And so in Alabama, wills don't have to be notarized. So in a situation where you have 1 witness and a notary, the law in Alabama said you can count that notary's signature as also as one of your witness signatures. But with the will, as I said, you're the one who's making that decision of who gets what. You're not leaving it up to me to decide that who gets the wedding photos or who gets some graduation photos or who gets granddaddy's military flag. You're the one who is going and making those decisions. And like I said, those are some of the things that we've acquired through our lives that may not have huge monetary value, but sentimental value. When you're looking at who's going to get those wedding photos, or who's going to get grandma's china, or who's going to get grandma's old piano, that those are all assets of the administration of the deceased. And so those are things that have to be distributed. And so those are also things that you've gone and thought about. Oftentimes when I talk to men, they say, well, I don't need a will because when I die, everything is going to go to my wife. And that's not true under the laws of intestacy. Event that you are married and you have kids together, then your spouse gets the first $50,000 and then half of the estate, and the kids get the other half. In situations where you're seeing more families are blended, and maybe the second marriage and the stepkids, and this often when it comes in, it really gets very acrimonious. And we've had situations where the stepkids have jumped on fought the stepmother over those things. In those situations, then, the stepkids step in, the spouse gets one half and the kids get the other half. And then you're in a situation of a house of possibly having to buy those children out of the home that you and your spouse had bought together. So it's not as clear cut and simple as people believe that it is, that it may can be. And often in those situations where the presentation, you're asking about the presentation that I had. Well, she can put it on the screen and we can go through some of it. I saw that I didn't have a clicker here to do it, so I can, really just kind of talk off my head, but if she pulls it up, we'll try to go through some of it real quick since we have it here. But like I was saying, that those are things that people, don't think about. That is not just clear cut, it's automatically going to go to your spouse. That if you've got kids, they stand to inherit as well. If you die with you and your spouse didn't have kids, then if your parents are alive, then your parents step in and they inherit half your estate with your spouse. So those are things to really go ahead and to think about. There are some things that, as couples are beginning to live together and not get married, and commingling assets that they can do, particularly with regards to buying real estate, buying a home. You can look at, instead of having it titled as joint tenants in common, that you do it with, joint tenants with the right of survivorship. That means that when one party dies, their interest automatically transfers to the other party. So if it's your intention, particularly if you've got stepkids or in situations where you're you have a life partner where you all have been together and you bought real estate together, and it's your intention for when one of you died, the other person to be able to inherit it, then that's a consideration. And when doing things like that also takes it outside of the probate court. But also when you look at doing the will versus someone dying intestate, there are more costs associated when you have to come before the probate court. Oftentimes in the will, the person making the will waives the requirement for that individual to have to get bonded. And that means that they don't have to get an insurance policy to guard against them acting inappropriately and administering the estate, handling the affairs of the estate, versus with the administration, when you have to file that with the probate court, that you have to do an inventory of assets. So you have to go through everything that individual owns. So cars, real estate, bank accounts, clothes, jewelry, yard equipment, everything has a value for that deceased person's estate, and you've got to get a bond in that amount of money to insure the heirs in case anything is done inappropriately with the estate, and there's some money there to go ahead and make them whole. And so those are some of the considerations, things that come into play when you have to go before the court. And like I said, the law of intestacy is different from what many people think it is. And so it's better to go and be proactive in doing the will versus coming and having to do the administration, because you're leaving it to the probate judge. Like I said, we're looking at distributing assets. We're the ones who have to go and make that decision over who gets what. And I'll tell you, as you're thinking about doing these documents, if you do them today, or if you decide that you'll make an appointment and see Mr. Pratt later, that it's important that you go and have these conversations with your family. Particularly with your children, when you're designating one to be an executor, or you're doing a power of attorney and you're giving the powers to one child or some others, that you let them know that it's your decision and why it is that you're doing it. Because those are also cases that can tear families apart when one feels, well, why did she let JC do it? I'm the one who's here taking her to doctor's appointments. I'm the one that has always been around, and he hasn't been as hands-on as I've been. But everyone knows their children. You know the ones who you think may be the most responsible, that are good with managing the assets and your affairs. But it's one of those things that you should definitely have those conversations, particularly when you have everyone home. When it really comes up in that Thanksgiving, Christmas holiday season, when everyone's sitting around the table, the grandkids are home, that you can go ahead and really have those discussions, because it leaves it up for people, as I say, kids having hard feelings later on when they find out that a parent has delegated one to be able to act on their behalf over another. She still had to pull it. Now, one of the other things that we'll talk about with the probate court is I get a lot of questions about power of attorneys. And many times people will come to me about a power of attorney. They'll say, Judge, my mom has dementia. I need to go and get a power of attorney. And I always caution people in those situations about trying to move forward, because I understand with Alzheimer's and dementia, there are periods when people are lucid and they're able to talk normally, but if challenged, you have to go, you have that medical diagnosis saying that they have a condition that may affect their ability to make decisions for themselves. And so the court steps into having to make a determination on this particular date and time, was this person lucid? Or was someone trying to take undue influence over this individual? And so as we talk about being proactive, as we're seeing maybe parents and grandparents maybe start showing signs of cognitive decline, that you be proactive when you start seeing those signs of saying, all right, we may need to go and get a power of attorney. So if you can't make decisions, we've already got it filed away, and I can go and pull it and be able to handle your affairs without having to come to the court for conservatorship to be able to handle your financial affairs, or guardianship to be able to make those healthcare decisions over you. But what is a power of attorney? And a power of attorney is really a document where you delegate those things you want somebody to handle for you. Sometimes they're not always done in situations where someone is incapacitated or can't make decisions. Some people do them in situations where they may be traveling out of the country for a while. I'm going over to, I got to go and go to, my job is transferring me over to Europe or to Africa for a year, and I need someone here to be able to handle my affairs here. And you can designate that person to be able to handle some of your financial affairs, your real estate affairs, handle your banking affairs. But in a power of attorney, you have the ability to give someone to handle all of your affairs, or you can be very specific in the things that you are going to let that person handle for you. The great thing about Alabama is that the legislature has a free statutory form that you can get for a power of attorney. And I brought a few of those copies here with you, and Mr. Kraft and his students can also go ahead and help you with it as well. But it's really just a simple form where you designate who's going to be your agent. You get a chance to decide what authority you want to give them. So you can decide, I want you to handle my real property or my tangible property, kind of like your personal property, stocks or bonds, bank affairs, insurance, litigation claims. But like I said, it's you that makes that decision. Now, one of the things we also find people run into sometimes with these power of attorneys, that you may have the individual who you're trying to get the power of attorney for may have had a medical condition or accident, may have had a stroke that has impaired their ability to sign their name as they normally could. You know, that we've had situations where someone got a power of attorney and they had them sign how they could sign it now. When they took to the bank, they're like, I don't know what this is. This isn't the signature that's on here. But there is a provision, Mr. Kraft will discuss that for you, where, you know, if they can, the person who you're getting the power of attorney to, they can show that they wanted to enter into the power of attorney and they wanted you to be the one who had the authority, then you can sign on their behalf and the notary can notarize it to help you get around those things. And so that's why some of the benefits of really taking advantage of speaking with an attorney regarding those things. And as I talk about it, it's much cheaper to have the power of attorney than having to come before, you know, the court and having to get a conservatorship or guardianship, because there are costs and fees associated with doing it. So when you file with the court and for a conservatorship, as I said, that's when you're asking for the authority to handle someone's financial affairs, or a guardianship and being able to make decisions for that person. One, you've incurred the filing fee, but then we've also got to appoint that person a guardian ad litem, and that's an attorney who represents the person who the conservatorship is guardianship is being sought for. And that person responsibility is to make a recommendation to the court, one, on whether or not they believe that person needs the conservatorship or guardianship, and two, whether or not the person seeking it is the best person to be able to act in that capacity. And so they've got to conduct an investigation, meet with the individual, their client, as well as meet with you, and then make determination. We also, that also a clinical individual that gets appointed, who also has to assess that individual to see whether or not they are in need of a guardian ad litem, and whether or not the person who's applied for it, petitioned for it, is the best person to receive receive that power. And then, you know, they also have to be examined by a physician. So those are three people who all have to be paid. And so you're looking at something that you can do really at virtually no cost by getting the state statutory form versus having to retain an attorney and to pay the guardian ad litem and the court representative and the physician for their assessment. So you're up into the few $1,000 range for something that if you were a bit more proactive and did at the onset when you began saying that someone may need one, that you can save yourself some money. And I'll tell you the thing about power of attorneys is that they can be revoked at any time. So just because you give someone a power of attorney to be able to handle affairs for them, if you find that they're not doing the right thing, you find that you no longer need them to act on your behalf, and you can go and terminate it at any time. And the other thing with power of attorneys is that they terminate upon that person's death. So once that person dies, you're not going to be able to act on that power of attorney to, handling financial affairs. The bank is not going to allow you to have access to any more funds, because once they learn that person has died, then the authority to act or the power of attorney ceases. Now, the other thing you have with the conservatorship and guardianship is that once the court makes a determination that that person is unable to make decisions for themselves, then that's more of a permanent decision. So if it comes to a situation where you're worried that your parent may get upset with you because you kind of change how they're spending their money, particularly when there have been situations of financial abuse, when you found someone, as they talk about now, those scams that go on where you find that they're sending money to people and that parent may not want you to do it and you're concerned that they may revoke it, then you can go and look at trying to do the conservatorship and guardianship route to be able to handle it. And the third thing I'll touch on during my time and I'll leave myself open for questions is, I know many of you all have gone to the doctor now and they have you check in a hospital and they have you checking on those kiosks and ask you, do you have an advanced healthcare directive? And that's a document that you would go ahead and sign and put on file with your physician in the hospital, that what you want to happen when you can't make medical decisions for yourself. If you find yourself in a coma, or you find yourself terminally ill, do you want to be able to receive life support, or do you want to have food and water? And so I know many of us have probably sat around our parents and grandparents, and they may have sat at the table and said, well, I don't want to be put on that life support. Don't put me on that mess. And it doesn't mean anything in that situation when it's not in writing. Because if you don't have one of these documents, then it falls on your spouse or it falls on your children. And children more than one. And if it's an odd number and they all can't agree, then the decision can't be made. And I tell people that with a lot of times with these documents is that they really present themselves in very emergent situations. That you may have been accompanying a parent or a loved one for what you believe was going to be a minor surgical procedure, and they come out and tell you they didn't code it on the table, and what do you want to happen? And right then and there, you've got to make a life or death decision. And particularly if you're in that situation, you got to deal with the emotion of the loved one that you have that's in the situation, dealing with the potential loss of them not being in your life. And then also balance versus them saying they may not want to be on life support and you're not willing to let them go, or at that position not wanting to let them go. And so because it's not you making that decision and there's nothing in writing saying what you want to happen, then that nurse, the hospital, and that doctor's got to take that person's, with what they say, decision that they've made that may not be in line with what you want to have happened. And so just like the power of attorney, there is a free form, out here for you to go ahead and look and fill out. And so it's very, very simple. And it asks you very basic questions that if you're terminally ill or injured, do you want to have life-sustaining treatment? Yes or no? Do you want to be provided food or water through an IV? It asks you the same if you're permanently unconscious. Do you want to be placed on life support? Do you want to receive food and water? And so, and then you designate who you want to be that person to make those decisions. You can make a first choice, you can go ahead and make a second choice. But like I said, it is you who's making that decision, and you're taking a lot of stress and pressure off your loved ones and your children for having to make that decision. And then finally, in a couple of minutes, I just wanted to touch on something that's something that we've dealt with at the probate court, and something that we've seen become a lot bigger problem here in Alabama, and that has really been the issue of property title fraud, which we've tried to address through our REACT program. And if you're not aware of it, property title fraud is when someone creates a fraudulent deed to take ownership of your property. And for many people don't realize that all of your real estate deeds are all public record. And anyone can pull up who owns any piece of property by looking at, the address or, last name. And the information that these thieves need is readily available. They know who owns the property because they have the deed, they have the property description language, that little paragraph that tells you, how many feet, right, left, and describes the size of the lot. And then in Alabama, because deeds don't have to be notarized, they just have to go ahead and create two individuals and forward some signatures. And once it's presented to my office or any probate court here in the state, we have to record it. That we don't have the ability to call up and say, hey, Reverend Shuford, did you really sell your house at this location, this plot of land here? That we've got to record it, and like that, your property's gone. And one of the issues with this type of fraud is that many people don't find out they've been a victim of it until much later down the road. Either they're trying to sell some property or try to refinance it, and it comes back as they're doing their, the title company comes back and says, well, there's issues, they're saying you don't own the land. Or you find out that you see a foreclosure statement in the mail saying they're going to foreclose on some property, foreclose on your home, and you don't even have a mortgage on it. Or you may find that you may not have gotten your property tax statement and call to the Department of Revenue downtown and find out that your statement's being sent to another address. And so we tried to address this for our REACT program, and REACT stands for our Real Estate Activity Alert and Contact Tool that really notifies you. Get a free email alert anytime any real estate deed or document is filed against any property you own here in Montgomery County. So you'll get an email notification within 24 hours of that document being filed saying you're receiving this because you signed up for the REACT program and there's been a real estate deed or document filed against your property, and giving you a copy of that document. Just so you can be able to notify the police that the property you own is here in the city, or the sheriff's department if it's out there in the county, so hopefully to be able to apprehend those individuals. Another thing that thieves have been doing here is you also have to be sometimes vigilant when you're looking at Zillow and Realtor.com, is now you're having people try to sell houses that they don't own. And I can tell you it happened because it happened to me, that I got a call at the office and said, hey, tell Judge Love that someone's up here trying to sell his house up here on Zillow. And because in those situations that all they need is pictures of your house, they don't ask you, those websites don't ask you to verify you own the property. You upload your pictures and you put a name about who they want. You want anyone who's interested to contact, and your property's out there listed. And so, in speaking with the closing attorneys and the title companies, they have been right at closing about to go ahead and finish signing documents when someone calls and says, hey, I hear y'all are trying to sell my home. And so these are something that the legislature has been trying to educate them on this issue and trying to look at ways where we can do a better job of protecting property owners here, not only in Montgomery County, throughout the state. And so I encourage you, if you haven't signed up for the REACT program, to please do it. Like I said, the website is www.react REACTNOW.com. It's REAACTNOW.com, reactnow.com. When you go to the website, it'll ask you to put in your name, email address. It's going to send you a confirmation email. And once you click confirm, you're enrolled. And so, you're enrolled permanently. Like I said, anytime, any type of real estate deed or documents filed against your property, you will get a notification. And the bad part about this property title fraud is you're almost victimized twice. The one, they filed this deed to try to take ownership, and even to the extent that they may have been apprehended or you thwarted them from being able to sell your home, then you still have to go probably look through hiring an attorney and paying a few $1,000s for him to get an order from a circuit court judge telling me to take that record out of that fraudulent deed out of our records, because the law doesn't allow you can't come to me and say, hey, Judge Love, I've been a victim of this. I need you to take this deed out of the records, that I can only remove it with a court order from a circuit court judge. And so, like I said, you're victimized twice. That one, they stole your home, and then you've been victimized again because now you've got to pay, some money to try to get title to your home back. And it's unfortunate that many of these, real estate, laws were passed, 70 years ago, and no one really contemplated that people would be perpetuating this type of fraud. But I know if you leave today or you pull out your phone and Google property title fraud, you'll find out that it's something that's going on in all 50 states. You may have heard the case where someone was trying the same scam against Graceland up there in Tennessee, and they were able to thwart it, where they said they had a mortgage on the home, they were about to foreclose on it. And they had to step in and say that there was no mortgage on it. So, it's one of those things that, you really have to be vigilant with your real estate. It used to be a time that many of us, last time we saw our deeds for when we were leaving the closing table, and we got it in that folder and envelope with the keys, and they wished us well. But, the thieves out here are trying to be very, very creative, and particularly about how they, with the sophistication of scanners and computer equipment, being able to falsify notary signatures on documents. And so you just have to be more and more vigilant with everything, because what you have, someone's out there trying to find a way to take it. So I did go ahead and see if anyone had any questions at this time. Yes, ma'am. Yes.
Okay, but is there anything that we can do to kind of prevent them? Like, I got a friend who I was in the yesterday. They said the first time about them wanting to buy the property. But you can put on here, return the sender. I can call the number and tell them it's not for sale. You can text them and tell them it's not for sale, but they still continue. And I believe they have pictures of everything. I'm wondering, is there anything that we can do to stop that?
Well, the question was, yes.
Would you please,
I was going to repeat it.
ask the question?
Yeah. I was repeating for the folks online, yes. Well, the question that she had was about, is there any protection for homeowners for these individuals who, send the notification through the mail wanting to buy your home? And no, unfortunately, they're not. Those are just real estate speculators. Many of them from out of state, because, the land in Alabama is a lot cheaper than it is in the Northeast and out in California. And so they can buy up a lot of property here for cheap. And so you have to be very, very, so there's no protection. But if you're not interested, you can do what you do. Tell them you're not interested. Don't contact me anymore. But then you have certain situations where you really have to be careful, because sometimes they'll send you kind of a check. I'm offering you X amount for your home. Here's the check here to go. And so, you really don't want to cash that check, because then, that is evidence that you've gone and entered into that sale. And so, But what this is really in those situations where, for most of us, our home is our most valuable asset, and that's how we've kind of accumulated wealth throughout our lives. And that we really want to try to keep someone from trying to steal and trying to steal it. Particularly, these people want the homes that don't have the mortgages on it, because ordinarily, if you try to record it, then your mortgage company is going to come back to you and say, "Who's this trying to file this mortgage? I've got first position on here that my mortgage hadn't been satisfied. So who this?" So, there are a lot of times we'll go ahead and catch it, but in those homes that have been paid for, or in those situations where there's air property where it's sitting out, a home that may be sitting vacant, or some farmland or some hunting land that you may have, that becomes very, very attractive because you don't have someone that's actively out there. And so they can easily be able to file one of these fraudulent deeds. And if they were able to get someone who said, "We want to buy and sell houses, we'll go ahead and do a cash sale," they check your records, they're going to see back here on March 25th of 2025 that Jay-Z purportedly executed a quitclaim deed transferring this house over to John Doe. And so the title company, in the event there was a mortgage company even involved, and they go back and check, then it's going to check out and say, "Yeah, this person owns it," that they have a title giving them ownership of it. All right. And I bring it back to you. That was something.
Okay, this is pertaining to, the durable power of attorney. So what I wanna know is, the durable power of attorney, is that just for medical stuff, or is it for everything? And, another question with that, do you have to have them redone ever so often, or if you do it one time, it's forever?
Well, I got this microphone on. With the durable power of attorney, that this is one that you can give them to, like I said, to handle everything, or you can be very specific in what it is you want to give them. So when you look at the form, page 1, it explains to you what it is and has you designate an agent. Then you have the ability to name your successor agents. It has a section where you can say, well, I want to give this individual the ability to handle anything that I can legally handle for myself. I want to give them broad powers to be able to handle it. Or you decide that I want to be very specific and I want to go ahead and you would initial those specific powers that you want them to develop, that be able to do on your behalf. Like I said, but the power of attorney, it's in effect as long as you want it to be in effect. So you can be revoked at any time, like I was saying. And the thing that I'll tell you about if someone gives you a power of attorney, that you still have an obligation to account for how, particularly when you're dealing with their money, how it's being spent. Because if someone comes back, another sibling saying, well, I believe that you're misusing mama's money or grandmama's money, that you're out here, you're buying a car or you're buying clothes on their money, that you need to be able to account for. The same way with you would on the conservatorship and guardianship, that you have an obligation, because we bring you back before the court every 1 to 3 years to go ahead and account for every dollar that you spend on that person's behalf, what you've done with it. And like I said, we still have a guardian ad litem who comes back, who reviews that account. And if there are any questions on how the money is spent, then you've got to account for it. And so, it's just that when you have it, there's still an obligation on you to act, in that person's best interest. And that's why if you're giving someone the ability to do it. You want to make sure that you're giving the authority to someone who you believe is going to be trustworthy, that they're going to appropriately handle your money and your affairs on your behalf. So you don't have that situation where having to come back and prosecute someone for misspending your money. Let me see if the microphone, turn it back. There you go. Hello?
Okay, I understand, but see, the thing is with me, I did one for my mother years ago, and I'm trying to see if it's still in effect. And it mostly is,
Is she still living?
yes, and I had to do it because she was.
Oh, then if she hadn't,
Sure.
if she hadn't, I wouldn't talk over you, but if she hadn't revoked it or said that it's not in effect, then it's still in effect.
That's not gonna happen.
But you can still,
But I don't have siblings, you know.
But yes, to the fact that, you know, it's still valid, if she hasn't revoked it, then you can still be able to act on her behalf. And one of the things that some people do with these power of attorneys, they do bring them down and file them with our records and recording division. So if the situation that you have, that you may have misplaced it, or if someone questioned whether or not it was valid, at least they can come and see that it's been recorded and you can go ahead and have it authenticated.
Thank you, sir. What if someone really got a power of attorney on somebody that's in the hospital, and they're spending all their money, the whole time they're in the hospital, and you really don't want to call elder abuse because, you know, they blood relationship. How do I go and get that revoked?
Well, the question that she had is someone is maybe in the hospital and they had a power of attorney, and the person been misspending their money and spent all their money. And what can she do to help that person? One, the person in the hospital, to the extent they're conscious, get them to go ahead and revoke that power of attorney. They go ahead and give a statement or something saying that they have revoking that power of attorney. They're unconscious, so they're not able to make decisions.
I mean, they state, you know, what I say there's nothing I can do, because I'm not, on the simple thing, and I'm not, you know, I'm just teaching students, so I stop teaching things that my brothers. Okay, but in the meantime, when I realized that somebody would take $7,000 a month, November, December, January, so February, I'll take, stop on the checks from going. So my thing is that how, you know, I got to, somebody in Pratt did a power of turn on. Someone in Pratt did a power of turn on. So how do I go and have that changed? Because I was headed down to your office today, but that's not coming instead. All right.
So someone did a new power of attorney for you.
Oh, no, they did a power of turn on, $100.
Oh, the one that's stealing all the money.
Yeah.
Well, you've got to, you know, one. Well, you know, in that situation, because they got a power of attorney, you may go ahead and have to probably consult with Mr. Kraft and look at trying to do a guardianship over that person. Just so we can, you know, the court can kind of step in and act if you don't want to notify the authority that person, that your siblings may have been stealing your mother's money, or you won't, or she won't do a power of attorney, another one revoking or doing a revocation of that power of attorney, then that'll probably be your best effort. You go ahead and file a conservatorship and yeah, down in my office. And that way we can go ahead and look at what that person is doing, and we can go ahead and look at appointing you and kind of cut that off. If you can't get your mother to revoke it, or do a new power of attorney, you know, revoke it out when that's done, that'd be probably the best effort. But make a point of talking with Mr. Kraft while you're here. I know, I guess I'm up on my time. All right, well, I thank you all for the opportunity to come here and talk to you today. That I hope you at least give you an overview of the topics and matters that will be discussed, and take advantage of the opportunity to talk with Mr. Kraft and the students, because it's not often that you have access to free legal advice. And so, if you have any questions, please feel free to give me a call down at the probate court, 334-832-1241, or email me at jclove@mc-ala.org. So thank you. And I'll leave these forms here in case anyone.
Thank you, Judge Love. That was a lot of information, and it's important information. Sometimes we don't want to talk about these things. Historically, people of color didn't trust courts, judges, lawyers, and so we have this tradition, an oral tradition. Mama would say, well, when I pass away, I am going to give you the house. Or your sisters and brothers are going to get the house. And everybody's name is going on the deed. That's a problem. And you're going to hear about that. You're going to hear about heirs property and what that is. It sounds like it's a positive thing, but it's problematic in our community. And I have to thank one of our elected officials for taking me on a tour in the communities of color that he represented here in Montgomery. And I saw all these boarded up homes. And I was wondering, why are there so many boarded up homes? And so I did some research and I learned that many of the homes in communities of color that are boarded up are heirs property. That means that someone or multiple people own this property. They've abandoned the property. They're not taking care of the property. And so the impact is very comprehensive. Number one, we're losing generational wealth. What does that mean? If it's a boarded up house, it's not paying taxes. The surrounding properties around it are going down in value. There's blight, there's crime, and it's a very devastating phenomena in communities of color across this country. I want to introduce you to our next speaker, Professor John Kraft. He is a clinical professor at Jones Law School, part of Buffalo University. He and his students are providing services to people who need legal representation through the Elder Law Clinic, and he's going to probably talk about that. Now today, you can ask him questions, but you can also make an appointment to see him about some of the things not only did Judge Love talk about, but others are going to be asking questions that may be of interest to you. So for simple will, powers of attorney, other legal documents, conservatorships, guardianships, he's going to be talking about that, and I want you to pay close attention because it's an excellent resource. And I want to thank him, and I want to thank the students and lawyers for being here for this, because they're taking time out of their schedules. We have a couple of senior law students that are graduating this year that are here, and they work in the clinic. We want to give them a hand and welcome them.
First of all, thank you, Ms. Neal. It's been a good partnership that we've developed, and I appreciate your effort and work in helping us to organize some of these events. Also, Reverend Shuford, we appreciate you opening the doors to the church so we can come and speak to your audience today. So, my name is John Kraft. I teach over at Faulkner Law School, and we operate a couple of legal clinics. So these are free legal clinics. One is called an elder law clinic. The other one is called our GAP, or Generational and Ancestral Property Clinic. And so I do want to talk a little bit about those clinics and how we might be able to provide services to you all. And then we'll continue our presentation and talk a little bit more about wills, powers of attorney, healthcare directives, and then we'll also talk about heirs property. So I'm hoping that you all will stay through the morning, and then we'll be here also through lunch. And so I'm willing to hang around, answer your questions, give you my business card if you're interested in coming into the clinic and getting some of this work done. So let me talk first about the clinics. So we actually have 3 legal clinics at the law school, and these are intended for the students to get some actual hands-on experience, like actually how to practice law. I don't know if this was like you in your profession, but when you go to school or college or graduate school or law school or professional school, when you get out of that educational experience, you have a lot of theory and knowledge, but you may have not had an opportunity to actually do the work and experience what it's like to be a lawyer or whatever profession it is that you're in. And I remember very specifically when I started law practice, this was a few years ago, not too long, but the phone rings and somebody says, hey, I need help with doing something. I think it was actually a trust. And I was sitting there going like, okay, first of all, what is a trust? Racking my brain, trying to figure out what I learned again in law school. And they were scheduling an appointment to come and see me. And I realized like, they didn't teach me how to do this in law school. Like, they didn't teach me how to communicate with people, how to be empathetic, how to counsel clients, how to draft their documents, how to tell them what could happen in their case or whatever that is. So I was pretty uncomfortable with this first meeting. In fact, my biggest fear was that they would ask, like, how long have you been practicing law? And the answer was like a week. So cross your fingers, here we go. But, here's the thing. In the law school, and things have changed a little bit since I've been in law school, but we, at Faulkner especially, but this is nationwide, take very seriously trying to help train our students, like to give them the practical skills that they need to be able to do the work of lawyers. So Riley and Emma are here with me today, and Emma's taken our clinics twice, and Riley's taking it this semester. So they have an opportunity to actually interview a client, to draft their documents, to provide counsel and advice. Part of that is from a learning perspective, right, to learn how to do that work. However, we're also a Christian law school, if you might know, and so we do believe that we're here to serve our neighbors in our community and to provide pro bono legal services for people who may not be able to afford a lawyer. So it's kind of dual purposes for us based on our mission, but also to help our students learn how to do the work. So Riley and Emma, they're going to speak here in a few minutes and talk a little bit about what they've learned in their two clinics. But let me kind of get things started a little bit with talking about the three kind of basic estate planning documents. So a will, a power of attorney, and a healthcare directive. Judge Love mentioned all three of those in his presentation. We'll dive a little bit more into the specifics here in just a minute, but you have a last will and testament, which is the document where you decide who you want to receive your property. It could be everything from the family Bible to your house, or your money, your assets, your land. So the will is intended to dispose of your property. Also in your will, you name what's called an executor, and that's the person who would be in charge of executing your will. So that's a will. And I'm going to ask you a question here in just a minute, so just to preview this question. I want you to tell me, which of these do you think is the most important document to have? A will, a power of attorney, or a healthcare directive. So that's what a will is. Now, a power of attorney in Alabama, the form that Judge Love shared with you all is a statutory form, and you could use that, although I do encourage you to get a lawyer to do this, power of attorney, for a lot of different reasons, but a power of attorney is essentially a document where you appoint someone else as your agent. So it's what's called a principal-agent relationship. So you appoint someone else to act as your agent, and then your agent can act in your place, in your stead. Now, in Alabama, when I talk about a power of attorney, really what we're talking about is a financial power of attorney. So there's a financial power of attorney. That form is essentially a financial power of attorney where you authorize the agent to handle your money, property, finances, business affairs. Think about it, right? So that's a power of attorney. And then the third document is called a advance directive for healthcare, otherwise known as a living will. So a living will is part of that. Judge Love mentioned if you go to the hospital, do you have a living will, right? So that's called an advance directive for healthcare in Alabama. And it's really two different parts to a healthcare directive. The first part is your living will, which says, do you want life-sustaining treatment if you are terminally ill or injured, or if you're permanently unconscious? Do you want food and water through a tube or an IV if you're terminally ill or injured and you're permanently unconscious? You can't communicate your decisions. So that's part of it, your living will, but also then you name what's called a healthcare proxy, kind of like your agent under the power of attorney. So the proxy then would be the person who's making those decisions for you. And we're talking about your medical decisions and end-of-life decisions. That's the healthcare directive. So my question, which of those do you think is the most important document to have and why? I guess show of hands maybe, and if you want to just tell me, I'll repeat out what you were saying. Who, anybody want to offer? Which of those do you think is the most important? Last will and testament, power of attorney, or the healthcare directive?
I would say the will,
The last will? Okay. So why do you say that?
because if God, the power of attorney is revoked anyway, and same with, you know, if you're not, if you don't like support or whatever, and you decide to take, somebody take you off, you die, still, you know, the will is the only thing that's gonna stay.
Right. So the will, you're basically is the only thing that lasts after you pass away, right? So the power of attorney revokes, or it ceases to exist upon your passing away. Okay, over here, somebody was going to have a comment. All the way in the back. So a comment in the back was a healthcare directive. Why do you think that is?
Because when I make a decision for yourself, you need someone to do it.
Okay.
Maybe they did not want that, and they later on came to it.
Right, so her comment was basically that if something happens to you, you need someone to be able to make your medical decisions for you. Anybody going with the financial power of attorney as the most important out of those documents? I see some heads actually nodding no. Well, I'm gonna guess, I'm gonna guess why here in just a minute. I think I know why. So, and I'll give you my own personal thoughts. I don't know if Riley or Emma wants to share when they talk about it either, but of course they're all important. I mean, I guess the answer to the question is, they're all important documents. I don't want to make it sound like you just need to get one of those three. You really need all three of those documents. You need a last will and testament. You need a power of attorney for finances, and you need a healthcare directive. So I think here's the theme for me is all of those documents allow you to maintain control over your own circumstances. So each one of those documents allows you to maintain control over your own circumstances. Think about that. You might be feeling a sense of loss. Sometimes that comes with aging. You start to sort of feel like you're losing control over things, or other people are trying to take control of things for you. So you kind of sense like, you're losing control, and it's a little counterintuitive to give somebody else power to do something. So what I want you to think about is just kind of reverse that mindset a little bit. Think about how you, by doing these documents, can maintain control over your person, over your health care, over your finances, over what's going to happen when you pass away. That's the way I look at it. It's like you can maintain control. And so a will allows you to decide, first of all, who's going to get your property. You want to say, here's who's going to get my land, my whatever it is, right? And it also allows you to control who is going to be in charge of your affairs after you pass away. A healthcare directive, you get to pick who you want to make your medical decisions for you if you can't make your medical decisions. And you get to tell them what you would like to have or not have as it relates to care or treatment, especially end-of-life treatment. So you get to say what you want and who you want to make those decisions for you. So the power of attorney is the one that a lot of people kind of hesitate, and when clients come into the clinic, often I teach the students, like, okay, you need to go through with your client, talk about will, talk about power of attorney, talk about healthcare directive. We can do all three of those documents. The one document that most people are hesitant about doing is a power of attorney for finances. And I think that one kind of goes back to this control idea again, do you really want somebody else in charge of your money? I'm with you, not really. Not really, unless it's my wife, I mean, she's kind of got control of everything already, but that's just what it is. But you know, again, it kind of heightens that sense of like giving power or authority to someone else to control your money. And that's not something that people really, that's not top of mind, something that you want to do, right? So it's a little harder to explain like why you need a power of attorney. So power of attorney, think about it now for finances again. Number one is you get to decide who you trust to be in charge of your money, right? Who do you trust to do that? So you get to decide who that's going to be. If you don't do a power of attorney and something happens to you, Judge Love has already kind of given you the answer to this question, but if you don't do a power of attorney, something happens to you, let's say you're unconscious or coma, or you can't communicate decisions any longer, then what's going to happen? Someone's going to have to go to court and become appointed as your legal conservator. That's not something that you want to happen. So in my mind, you'd much rather like decide who you want to be in charge of your money, property, finances, versus not knowing it and then something happening to you and a judge. I love Judge Love, I do. You know, but ultimately it's going to be his decision. Okay, this person here has filed a petition to become appointed as mom or dad's or sister or brother's conservator. And he's either going to grant that petition or he's going to deny that request. Or somebody else, another family member might come in and say, you know what, no, they're not like, you don't need to appoint them, you need to appoint me. Then we have a trial, people are going to testify, and the judge is going to decide who to appoint. At that point in time, you are the subject of this proceeding. So all the testimony in court is going to be, is this person incapacitated? The judge has to determine, yes, they're incapacitated. Do they need a guardian or conservator? Yes. And then who to appoint. So at that point in time, again, what has happened is you've lost control. Other people are deciding who's going to be in charge of your money, property, finances. So that's a bit of a threat, I guess. The other thing about a power of attorney, a threat in other words, I hate to like say, do these documents or else bad things are going to happen, but that's really what happens. If you don't do the documents, bad things could happen. The other thing about a power of attorney, why I think most people will hesitate, is that they have seen someone else abused or financially exploited by a power of attorney. So they've done the power of attorney, or somebody else has taken them to a lawyer's office to do a power of attorney, or they've printed a form off the internet and the person has signed the power of attorney. Next thing you know, the person who they've appointed as agent is Mike went out. I'll just speak up for it. There it goes. Next thing you know, the agent's like, hey, I'm going to use this person's money because I need some stuff myself, or I'm going to give it to somebody else or whatever. There was a case in Prattville. I don't know if you follow the news. It's hard to watch these days. But anyways, if you do see the news, there was a case in Prattville where the son, and unfortunately, I hate to say it, it's most often family members. You know, you hear about like stranger danger scammers, and there are people out there, hey, can we buy your house or steal your house for money? Like there's scammers out there, just random people who call. But unfortunately, most financial exploitation is committed by someone who's close to you. And so this particular case, the son got a power of attorney, his mom, now she's the agent, right? So she signed the power of attorney, appointing her son as her agent. He proceeded in about 18 months' time to spend about $450,000 of her money. Where do you think it went? Drugs, alcohol, his girlfriend, and the casino. And yeah, you know, and actually he got caught. So I'm glad he got caught. He went to jail. So this is, look, here's the bad part about that is, it doesn't always happen. Like people get away with this, unfortunately. People get away with it. So I guess what I wanted to tell you about power of attorney, following up with what Judge Love was saying, is it is criminal if you abuse a power of attorney and you exploit that individual. So in this case, the Alabama Securities Commission got a report because basically the lady went in to see another lawyer, actually took his mom in to see a lawyer to get her will done, to disinherit his sister so that everything came to him. Well, the lawyer, look, this lawyer did a great job. They knew something was up, like this ain't right. Mom was not really competent to make a will, and Riley, I've asked Riley to talk about that capacity, like what does it take? Mom was really not competent to make a will, but the son was just trying to force her to a lawyer's office to redo her will. And after a couple meetings with mom, and there were some caregivers around the home that were like, hey, he's like taking her money. They ended up reporting that to the Prattville Police Department, the attorney did. And once the Prattville Police Department looked at it, they got the Alabama Securities Commission involved. And trust me, you don't want them involved because they will go full bore. So they prosecuted him. He pled guilty to felony charges, elder financial exploitation. So, but anyways, back to my point. That's maybe what you're thinking about not doing a power of attorney, because that could happen to you. Maybe you've seen that happen to family members or friends. That's a valid concern. So one thing that we'll talk about as well, and I'll answer your question, but there are ways you can set a power of attorney up to avoid that. So don't just not do it. Go see a lawyer, even if you have to pay a lawyer. Go pay a lawyer, go by yourself. Don't let anybody else drag you into the lawyer's office. Go on down there, pay him whatever it costs to do a power of attorney. Get good advice from that attorney on how to set it up so that you can try to minimize that possibility from happening. Okay, so those are the 3 documents. Now, I've probably taken like way more time than I was supposed to. We've got, how long we got? Till 11:15, I think. Is that about right? Till our break. Who's got the agenda in front of them? Yeah, okay. So let's spend about the next 15 or 20 minutes, and I'm going to ask one of my students, Riley Edmondson, to come up. He's taking the elder law clinic with me this semester to go back over a few of like the different specific aspects of making a will or a power of attorney or a healthcare directive. Okay, Riley?
Good morning, everybody. Good morning. My name is Riley Edmondson. I'm a 3L at the Elder Law Clinic. And so before I get started on this Professor Kraft's questions, we've kind of been discussing this, during the semester at the school and the clinic. We have a few of the students we go back and forth. So I would say advanced healthcare directive would be the most important, because if something happens to me, and I'm in a coma, I want them knowing who I want to make my decisions, what I want done. I don't want them going, let's hope it gets better. Let's open that will up, see who gets his watches if he doesn't know. So that's just kind of the way I look at it. So I'm going to talk about estate planning, focusing mostly on wills, but some of the touch on the others. And I know we're throwing out a lot of phrases, a lot of terms you might not have heard before, but just when we talk about an estate plan, so that is just all of these documents we're talking about together. A will, advanced directive for healthcare, power of attorney, all of those together are an estate plan. You can have one of these, you can have all 3 as we typically prefer. So diving into a will in particular though, and I'm looking at my phone, so I know I have my PowerPoint. It's a beautiful PowerPoint. I only say that because I made it very basic when my wife made it look a lot better. So it's a real shame y'all can't see it. She'll be very sad when I tell her this. But the 7 aspects of a will that we're going to be looking into. 1 is the standard to make a will. 2, the types of distributions that you include in a will. 3rd, what happens when a beneficiary of the will dies before the person who made the will. 4th, disinheritance clauses. 5th, the requirement to execute a valid will, and what are called self-proving wills. I kind of talked about those a little bit. 6th, appointment of fiduciaries, and 7th, how a will can be revoked or changed. So the standard to make a will. So for a person to make the will, they must be 18 years of older and of sound mind. Well, sound mind is a very basic term, and you might say, well, what does that mean? Well, sound mind means the person has testamentary capacity. Now you might say, what is testamentary capacity? So when you're evaluating that, you look at 3 things specifically. So the person needs to, 1, be able to recall the property they want to be devised. So they can't just say, I want to give, this, but you're like, well, what do you want to give? I want to give something. You got to be able to know what it is. 2nd, you need to know who you want to give that property to. Who do you want to receive that? And 3rd, you have to be able to put these 2 together. So, it's not a super hard bar to cross, but it's something that if you can't meet it, it's going to be very noticeable. So then we're going to move into the types of devices in a will. So typically in a will, you have a specific device, demonstrative, general, and residual. So a specific device, this is just a device that passes a particular piece of property. So typically in this, it's tangible personal property, car, jewelry, something that has significant monetary, sentimental value. You don't, a lot of times in this, you don't just want to list everything you have. This is like particular things of property, maybe a ring you promised to a grandchild, maybe you have a record collection you're proud of, you know that your family, that means a lot to them. This is something you kind of specify to make sure that your wishes are followed. I know we talked about this earlier, but this is not something that, you've got to make your will and go, well, I already told so-and-so that they get this. I don't need to include this. You always want to put it in there because, someone forgets, someone can disagree with that. And you want to stop those fights. And so a lot of times with this as well, you don't necessarily even have to say, I want to give, so you can have methods of distributing your property. And one of the good things is a will is it can kind of be tailored to exactly what you need. And so just a few examples of the methods that we've seen, devising this tangible personal property. You can have everyone you want to give something to, you get a hat, you put numbers in it, and then you draw that and they take turns picking the property. That was one of the more unique ones that we've seen, but it works, it breaks it up, it's fair. Two, you can just kind of, some people just group it by category, give it to them like that. And then, sometimes this is the one that we don't necessarily like, but some people want it, is you just allow them to pick, leave it up to them. But again, that's not the purpose of the will. So that's kind of like last case, like, I don't really know. But you want to, this is your will. And again, you want your instructions to be followed. So don't be scared to put these in the will. So then moving on to demonstrative devices. So this is a gift of a specific amount of money or quantity of property from a particular source. So you could say, I give $5,000 from my bank account to my son. Or I give shares in this company to my daughter. So these are more like specific things that you have. One of the things you need to look out for with this, though, is if you have like a joint owned bank account, if that is jointly titled, that's just going to automatically pass to the surviving owner of that bank account. So, if there's someone on there who you don't want to receive that money, you need to get that taken care of. Then you have a general device. This one is pretty simple, as it says. It's just an amount of money, but you don't even have to name the source. So you can just say, I want to give $10,000 to my church. You don't have to state your bank account, don't have to go into specifics, but it's something that gets followed. And then you have the residual. I'm sure you can guess what the residual is. It's just everything else that's left. How do you want to divide that up? And so typically in a will, you'll just see, I give the residue and remainder of my estate to X. And then typically you see N equal shares, and a lot of times you want to leave this called per stirpes. So this means if you have 3 children, you leave it to them per stirpes. If one of the children were to die before you, the amount that they would have got just goes to their kids automatically. There's no need for you to go back and change it if that happens. All right, so what do you want to do if you want to exclude someone from your will? So one of the most common additional clauses in a will is a disinheritance provision. So it's important to remember that you have the right to exclude anyone you choose from your will. The only exception is a spouse. You can't disinherit a spouse unless that spouse disclaims their right to their estate. But that would be a bit hard to do anyways. So then, who do you need to think about excluding from your will? So first off, you want to do closest blood heirs. So a lot of times, you need to specifically exclude them because if you don't, they can try to have a claim through intestate succession, take it before Judge Love, try to argue that even though they weren't specifically given something, they still have a right to it. And then another one you need to be careful of is anyone you gave something to in a previous will. You don't want to just, say you gave it to your friend. Okay, you don't have a falling out. Later on, you change your will. Don't just not mention them. Specifically put a disinheritance just to make sure that there's no argument about who you're giving your stuff to. And so then how do you execute a will in Alabama? So there's 3 required elements. The first is that the will be in writing, typed or handwritten. The second is the testator's signature, the person making the will. So this is a little bit that Judge Love is talking about. So obviously you can sign it yourself. That's going to meet the requirements. Or second off, the testator's name can be signed by someone else at the testator's direction and in their presence. So if you're unable to sign for some reason yourself, you can direct someone to sign for you. If you're there, that's still fine. There's no reason to have a problem with that. And the third is witnessing. So you have to have people there who witness you making the will. Typically it's 2. So then, of course, this leaves the question, what about notarization? Judge Love talks about having a notary there. So a notary is not required to have a valid will in Alabama. You don't have to have that. But the benefit of having a notary is this makes what's called a self-proving will. So with a notary in the attestation and witnessing statements, they take the form of a sworn affidavit, and with a self-proving will, compliance with the signature requirements are conclusively presumed, and the other requirements for execution will be presumed subject to rebuttal. So this is one of those things, we want to make it easier for Judge Love. We don't want to cause more problems going in front of him. So when you have this notarized, you speed up that process of who gets your stuff once the will takes effect. Another thing that you need to consider is an appointment of fiduciaries. So then obviously you know the executor, they're the one who executes the will. They follow the instructions you leave for them. And so this is one of the toughest decisions that you see, especially with multiple kids, is who do I appoint as the executor? You know, you feel like you might be choosing one over the other, causing some strife. But what you need to look at is one, trustworthiness. It's kind of hard to say that you don't trust one of your kids as much as the other. And two is the availability. There's a lot of things that people don't consider is who's going to be here? Who's here if I need them? Who's going to be here already if the will needs to be executed? So these are two things that you need to look at. And you know, again, there's flexibility here like there are with a lot of these. So if you want, you can have them appointed in order. And so like this person serves unless the other person is able to. Or you can even have them serving as alternate or jointly, causing them to work together. So that's one way. If you have two kids and you're really stuck, let them join. Make sure that they work together, make sure that your wishes are followed. And a few other appointments that you typically see in a will that you might want to include is the trustee of a testimony trust created by the will. So if you have a minor that you're leaving a trust to, you can put someone in charge of that. And another is the appointment of a guardian for minor children or a dual disabled child. So these are just, again, the benefit of a will is you can tailor it to your own needs. So these are some things that if you want to include in there, feel free to. All right, so then how do you revoke a will? What if you made a will and you want to change it or you don't even want to do one? So a will can be revoked in three ways. One, operation of law, which just means that if a testator is divorced after making a will, then all the gifts that were presumed to go to that spouse no longer are. The second way is a physical act. So a will can be revoked by being burned, torn, canceled, or destroyed with the intent of revoking it. I definitely wouldn't recommend this method. It would be hard to argue that later on, but that is one way. And then the third most common way a will can be revoked is by a subsequent written instrument. So by making a new will, you go ahead and in the process of that, you revoke all prior wills and show that this is the one, like this is your final will. And then another important thing that you see a lot is when revoking a will, making changes to a will, you cannot have your will and just write in the margins or write on the sides and think that that's going to be enough if you have to go to court, because it's not going to be. So you have to go in and actually change the will. And I know it can be a bit of a hassle at times. Let's just say you move. You might not want to have to change your will because of that, because like everything's the same, I just change the address. It's worth it to make sure that it's updated. So then moving on to the powers of attorney. So I know we talked about this a little bit ago. So a power of attorney is one of these advanced decision-making documents. It's a legal instrument declaring another to be the principal's agent and empowering another to act on behalf of the principal. So typically this is where you see a financial power of attorney. And so one of the things that Professor Kraft was alluding to is your options when appointing agents. It's another thing like with a will where you have options on how you want people to do. So again, you can appoint your agents to act in order, or one person at a time, or you can have joint agents who must act together in an agreement. So when you have something like this, banks therefore are going to require the presence of both of your agents before they can make any withdrawals or do anything on your own behalf. So an advantage of this is you put some checks and balances on the people you're giving your power to. That may slow it down if they have to make a quick decision, but if you want to make sure that you're protecting your stuff, this is important as well. And I know one of the things to make you worried about with the financial power of attorney is you're just giving your stuff away to someone else right then. But there are a lot of options that you have with this. So obviously you can have an immediate power of attorney where you just come in, you sign it, and you say, I'm giving all this, whether it be your specific or general stuff, to your agent. But what you can see and what we typically would like for you to do, unless you need to give it away, it's called a springing power of attorney. So you go ahead and get your document made, so it's there whenever you need it, but they don't have any power until you're declared incompetent. So that way, you don't have to worry about getting this document made, but you still are protecting your own stuff right now. So then another thing is for the Advanced Directive for Healthcare. This is typically, at least through our plan, we have two documents that are put in this. One is a living will. The living will is where you make decisions about end-of-life care or treatment. And so you have some of the basic stuff, like I want to receive life-sustaining treatment while I'm in a coma, food and IV through that. But there's a spot as well for specific things. You might have, whether it be religious or personal reasons, but you don't want certain things done to you. You can include these in your Advanced Directive for Healthcare. And then the second is the appointment of a healthcare proxy. So this is someone, obviously this document is meant to cover, to protect you if you fall ill and you can't make decisions for yourself. But we all know this can't cover everything. So the same thing with the will, when you're appointing someone to make these decisions for you, you want to think about, are they going to be nearby and how much do I trust this person? Because this could be some of the most important decisions that they're having to make for you. That's all I got. Thank y'all.
Okay, thank you, Riley. I appreciate that. I'm glad you're learning just a little bit as we go through the clinic this semester. So before we move on to a different topic, which will be heirs property, do we have any more questions about wills, powers of attorney, or healthcare directives? I'll repeat the question too once I hear it. Go ahead.
So I don't.
We're gonna play by the rules.
Okay.
Good.
Good morning, Karen Jones. So for those of us who don't have kids, but I have property and I have an organization, what category am I? When writing a will, I have 7 brothers though.
Okay, so when you write a will, you're acting as yourself, first of all, right? So would you say your name was
Karen Jones.
Karen Jones. So your will will be Karen Jones. So a couple things if you will, you don't have to have a spouse or children or anything like that. You can give your property to anybody you want to. So you can name specific individuals in your will to receive your property. And again, that could be anything from land or personal items and stuff like that. So you can list specific individuals to receive your property upon your passing. You can also give your property to an organization. So for example, a lot of people want to give property to a church or a charity or other type of organization that they're familiar with and they support their work. So in your will, you can give your property to specific named individuals or organizations, one or the other.
And pets.
Pets, yes.
Same thing, who you want to take care of your pets.
Correct. So the question is, how do you handle your pets? And I've got a golden retriever, which I guess I could put her in my will, but a lot of people love their pets, and that's an important thing. And so we do, and you would include your pet in your will. Your pet, your dog or your cat or whatever type of pet is a type of a tangible personal property. So you can just list in your will, I give my dog to whoever, and that would be a gift to them. Sometimes you can put instructions in there. Sometimes we have clients who want to put some instructions. I give my dog to whoever for them to place an appropriate home or whatever, and it's my wish that my dog not be put in a shelter or something else. So you can kind of give some instructions to that person as well as what you want to do with your dog or your cat or another pet.
Okay.
Okay, good question. Come on up to the mic, I guess, although you're right there. All right, come on then. You're good.
The person who you designate to be your belongings in the will pass before you do, and you have time to change it, what happens?
So the question is, basically, what happens if you've given something to a person in the will and they died before you have a chance to update the will at that point? So what happens there is, Riley mentioned what's called a residuary clause, and that's like the very last part of your will. So let's say I've gone through my will and I've got this is going to go to that person, and this is going to go to that person, and this is going to go to that person, whatever. and like one of them passed away. At that point, what happens is that gift has lapsed, and it goes down to your residuary, kind of a catch-all. So it doesn't get lost, it just, because that person is no longer living, it goes down to the bottom of your will, to where the property can be distributed equally among whoever, right? So there's always a catch-all there, to where it's gonna be handled, you know, if you're not able to say.
Where should you keep your will? Should you need copies like this?
Yeah, so good question. Where should you keep your will? First, my friend Danielle Rudolph. Okay, so Danielle, we've done a bunch of, I haven't mentioned Danielle Rudolph, by the way. Danielle's a friend of mine and a colleague. She works at Alabama A&M University with the Virginia Campus Lifelong Learning Institute, formerly with Alabama Cooperative Extension System, and she does a lot of work with them as well as us in terms of events. We've done a bunch of presentations on keeping your court papers. So there are some materials that you might want to check with Danielle about in terms of how to organize your papers and keep your court papers. Of course, one of those is your will. So you need to keep it in safe storage. Typically, what's going to happen is when a lawyer executes your will, they're going to give you the original notarized version of the will. You know, you want to keep that in safe, a safety deposit box, somewhere where it's protected. Keep it wherever you keep your full papers, and they also, it needs to be accessible to whoever the executor is. So whoever you listed as executor of your will needs to know where it is, how to be able to get the will on faster. We do have some materials with that. It looks like y'all can grab some of the way out in terms of organizing your papers. And same thing would be true for your power of attorney, healthcare directive, all those little documents you want to keep in the same place to make sure that your executive, your agent has access. As far as copies are concerned, it's a good idea to make copies. So if something happens and the original will was burned up and fired or something like that, there is a way that a copy can be admitted to probate. It takes a little bit longer. So I would give a copy as well to the executive. You know, make sure the original is safe, give a copy. Okay, we have one more question and we'll.
This young lady asked a question about the person died, that you have, and you said that how that person can, she did not have a bad person.
You can, that's a really great idea. So let's say, I don't know, especially something that's really important to your family or a particular piece of property that you want to go with somebody. You can always draft in your will to say, I give this to that person, and then you could go ahead and put back up plan in place right there. You could say, if this person dies before me, then I give it to whoever. Yes, I'm going to leave it to chance. You still be covered, you could go ahead and put that sentence right here.
If the owner or owner of a piece of property does not pay taxes, at least it was suspected.
His question is, what's the statute of limitation on a property sale? The answer to the question is no. Sorry. I don't know the exact answer to your questions. 3 years. Oh, 3 years from the fact.
3 years. Okay, if someone comes in there and pays the property taxes on the outside of that, how many years that person can pay it to be owner of that property? My family experienced a situation like that a few years back. The property taxes was not paid within X number of years, and there was someone that came in and paid the taxes, and we was told by the court that if they had paid it one more year, they would have had ownership of the property.
So there's a lot in that question.
Okay.
Here's what I want to do. There's a part that I do want to answer to that question, but let's talk talk later, because if you've got specific circumstances, we probably need to talk about that privately and figure that out. Here's the other thing, just so you know, paying the property taxes does not make you the owner of the property. So that's a myth. So just realize that it has nothing to do with actual title and ownership to the property. Paying the taxes does not make you the owner of that land. So that's part of the answer to that question. Okay, so let's do this. Let's see what time I got right here. Yeah, let's talk about Heirs property. But let me wrap just a minute about the Elder Law Clinic, and then we'll talk about Heirs property some as well. I do have some business cards with me. I'll put them on the back table there. You can grab one on the way out for the Elder Law Clinic. I'm going to give you some bad news. If you want to do a will, you're probably going to have to wait until August. So the reason for that is these students right over here are getting ready to graduate, and I won't have any new students in the clinic until the fall semester starts. So that's one sort of weakness of our program, is it only operates during the school year. So think about fall semester, spring semester. And so if you're interested, the times to call us would be like August or July, right before classes start, and then January before the spring semester starts. And that's true of the GAP clinic as well. We'll talk about that in a minute, because, you know, even though we have cases that we're running year round, as far as new clients, we typically don't take new clients except for at the beginning of those semesters. Okay, question?
This is a question. What is the age to be considered elderly?
Oh yeah, that's a loaded question, isn't it? So what's the age? So for our clinic, 60 and older. So for the Elder Law Clinic, you have to be 60 and older to qualify for services and just not be filthy rich. I can't refuse not telling the story, but we did have a lady who called, it's probably January, and she was interested in getting an update to her will, and I asked her a few questions about her property and what she was wanting to do. And then one of my students was talking to her as well and said, well, ma'am, can you tell me a little bit more about what you have? Because we need to know, like, if it's something that a student can handle, right? We don't do trust work. We don't do a bunch of fancy dancy estate planning, you know, kind of thing. So trying to figure that out, and she just really wouldn't like come clean in terms of what she owned. And the student was like, what do I do, Professor Kraft? I said, well, just ask her like directly. So she called the lady back and she said, well, ma'am, you need to, how much do you have? And she said, oh, do you mean my net worth? And the student said, well, yeah. And she said, 45 million. So I was like, well, that's not going to be a client. She could go pay a lawyer somewhere, get that done for her. Anyway. So there. So anyways, if you got $45 million, don't call me. Look, if you got a house and you're on fixed income, even if you got a little extra property or land somewhere, we can probably handle it for you. We don't do trust work. So if you do feel like, you know, maybe a trust would be something that would be appropriate in your circumstances, we don't do trust. But, so that's the extent of our Elder Law Clinic services.
So you said it was 60 and older.
60 and older.
You come there and call.
Call, I've got a business card on the back table, and you just call that number, and I would say end of July, early August.
Is there an income level or not?
No, I don't have an income limit. So we'll do an intake with you. So either me or one of the students will go through what it is you're wanting to do, what your property assets look like, and then we can tell you, like, it's something we can do or not, depending on your circumstances. Okay, let's talk about heirs property. And you know, anytime we talk about heirs property, whoa, oh my goodness gracious, talk about a thing. And you know, we're working with Danielle and Alabama A&M on a project currently over the next couple of years to help educate and to prevent the creation of heirs property. So one thing about heirs property is doing a will can help you prevent creating heirs property. And heirs property is just land that's passed down generations without a will or without going through the probate process, and all of a sudden you're sitting there and the deed is in 2 or 3 generations back. And Emma's going to talk about that a little bit, but you know, doing a will can prevent the creation of heirs property, because you say who you want your land to go to in the will. And through that process, a new deed is going to be written to give that property to the new owners, right? So will, to prevent it. The other thing is to like clear title. So when you're thinking about heirs property, there's an issue of how do you fix that situation where it's passed down generations? How do we get good title to the property so the current owners of the property can actually put it to good use? So that's what heirs property is, and we do this work at the law school as well. So I want Emma Gulat to come, and she's going to talk to you a little bit about her work in our GAP clinic, generational ancestral property, and what she's learned about heirs property.
Good morning. My name is Emma Galat, and I'm a third-year student at Dillon School of Law, and I am working in the generational ancestral property clinic this past semester. And today I'm going to touch briefly on what heirs property is, the risks of holding heirs property, and the legal solutions to clearing up title issues with heirs property. So briefly describing, heirs property is land held without clear title, and it was once held by someone who died without a will, and that property is now owned by multiple family members by inheritance. So this property comes into existence when someone passes without a last will and testament, some sort of trust that is holding the land, a deed, or some other instrument which would transfer that interest of real property from another person. So the risk of having heirs property, there are several economic consequences of holding this fractional ownership interest. So the first is profit sharing. If the land is used for anything such as collecting resources as crops or timber, those profits would have to be shared by potentially many heirs. And so that's ultimately an underutilization of the land. Another issue that owners of heirs property run into is that banks almost always refuse to loan money against this land. So it's ultimately defeating one of the main benefits of owning land in the first place. And another is that clearing up this issue of this fractional interest requires unanimous consent of all the heirs. So you're going to require a lot of participation of a bunch of different individuals, all requiring the same objective and being on the same page to try to reach the same goal. And lastly, the land itself is just largely undervalued. And so we are wanting to avoid all of these issues, but in order to begin this process, we first have to determine who all the heirs are. And so the heirs are, the heirs are defined by Alabama law, and they are any person, including a surviving spouse, who are entitled under the statutes of intestate succession to the property of the decedent. So these potential heirs can include spouses, naturally birth children, and legally adopted children, parents if there is no spouse or children, siblings, grandparents, and family related through grandparents such as uncles, aunts, and cousins. And there is a presumption that a decedent does have heirs. So we anticipate that a party will have a legitimate interest in the estate and that they will come forward at some point. So we don't assume that just because someone did not have a spouse or children that there is no one that will come forward at some point in time. And the solutions to all of these issues in heirs property, the Alabama legislature passed the Alabama Uniform Partition of Heirs Property Act in 2014. And this was designed to preserve the wealth by creating a hierarchy of remedies that protects the property rights of these individuals that are traditionally most at risk for losing their rights and protecting land wealth during partition sales. So the Act defines heirs property as real property held in tenancy in common that satisfies all of the following requirements. So there cannot be an agreement in record binding all of the co-tenants which governs the partitions of the property. There cannot be, there must be one or more co-tenants who acquired the title from a relative, whether that relative is living or deceased. And any of the following applies. 20% or more of the interests held by co-tenants that are relatives, 20% or more of the interest is held by an individual who acquired the title from a relative, or 20% or more of the co-tenants are relatives. So the Act supplements the partitions in kinds and partitions by sale with a statutory preference for a partition by allotment. And so it clearly sets out a procedure for the court to follow when a co-tenant requests a partition by sale. And this essentially protects all of the interests of any potential heirs to the property. So it requires that the co-tenants must be notified of their request and informed that each co-tenant who is not requesting a sale, they have 45 days to purchase the interest of the petitioning co-tenants. It sets out how this, the purchase price is determined, and then that the court will notify other co-tenants of the intent to purchase and buy, what the price to be paid is, and then the co-tenants will have 60 days to provide the required funds to the court. So it's a rather lengthy and rigorous process for the notification requirements, but it works to provide notice to any and all of the living heirs to the property and to keep this family land within the family. So one way to clear heirs property issues that we use in the clinic are through affidavits of heirship. So these affidavits will prove the timeline of heirship if intestacy is involved. And then another way to clear these issues of heirs property is through filing civil actions in court to clear up title. This is often the most costly and time-consuming, though it does result in the clearest title available to the property. Another way to avoid the issues of heirs property is through utilizing mediation. Often there are tenants that have an interest in this property that really don't have any sentimental value or interest in the property. So in these cases, it's especially more useful to try to use mediation when there is a tenancy with a strong connection and those without, and there is the sufficient monetary resources to be able to purchase that property from the other co-tenants. And lastly, the other alternative is to be proactive in all of this and creating legal instruments which would effectuate your wishes. Not only last wills and testaments, but you could also utilize things such as land trusts, limited liability agreements, tenancy in common agreements, and wills as well. So each of these solutions to heirs property, whether it's filing a civil action, heirship affidavits, or other means through probate court, this will all depend on the client's goals, whether you're wanting to stop the fractionalization process of the property, obtain marketable title, apply for loans. This will all depend on what we're able to use legal-wise to assist you. So through creating an LLC, this would essentially convey, all of the heirs would convey their interest into an entity. And from there, rather than having a unanimous consent among all the heirs of how the property would be maintained and function, it would be based on a popular or a majority vote of the members of the LLC. Another option of the land trust and the tenancy in common agreements. The tenancy in common agreements, although it would resolve the fractionalization issue of the property, it would resolve how the land would be maintained over time and upkept. And another option too would also be just to consolidate the land into one individual's name by deed. And lastly, the will execution. So while writing the will alone is not going to cure the issues related to the heirs property, it will alleviate any other fractionalization that could occur, and effective estate planning will typically halt further fractionalization and will be effective. And back touching on those affidavits of heirships, just to expand on the different legal avenues that we use in the clinic. So while it seems that it's just a document proving the timeline, it does include a ton of information regarding the deceased individual, their family members, so they would have to be able to recall their spouse, the children, the grandchildren. So after some time, it does become a lot of information if it becomes so far removed. And so it's best to go ahead and try to prevent trying to use heirship affidavits or the court and try to stop it at the bit and go ahead and get those wills done, make sure your interest is secured. So it's important to take these preventative measures and to ensure the stability of your assets for your family. But I would like to thank you all for coming today, because by being here, you're already 2 steps ahead and getting ahead on this process. And that's all I have for you guys today. Thank you for your time.
Done good. You know what? It's me kicking this thing down here that's causing that. I didn't realize that earlier. I was kicking it, so I try to not do that. But appreciate you, Emma, and giving us a little bit of overview on heirs property. This is not my expertise in terms of heirs property. I like to stick to the wills and powers of attorney, stuff like that. Two other things let me mention about heirs property. One is it can lead to land loss. So you can lose your property. Because what happens is over generations, Emma mentioned that these interests are fractionalizing. So after every generation passes away, you have more heirs and you've got new heirs. You could end up with tens, hundreds of heirs who each have what's called a fractional interest in that property, a 1/50th interest in that property. And legally, their ownership is what's called a tenancy in common, or as tenants in common. So they each have a 1/50th interest. Problem with that is they can sell their 1/50th. So that person can sell their 1/50th without the agreement of anybody else. And what's happened is sometimes developers might come in, they can buy out a 1/50th interest in this property and then try to force the sale on the property. And the rest of the heirs can't afford to buy the property. So, you may have read stories about loss of property where, I don't mean to name developers, but this could happen, and it does happen. To where that land now is all of a sudden subject to a forced sale on the property because someone wants to build a Walmart or whatever it is, wherever that land is. So that's another good reason to not only try to avoid it by doing a will and putting it in your will who you want to receive that property. The probate process is intended then for the deed to that land to be transferred out of the name of the previous owner into the new owners who are being listed, right? So you want to do that first. But also, you want to try to clear these things up and get that ownership in a place where it's more secure. So things that we talked about, Emma was mentioning, is you could consolidate ownership into one single person. Maybe there's one person who's actually using the land and they're going to be the one that's maintaining the property. It could be a number of individuals. You could put it into a business organization like an LLC or a trust where you could take all of those 50 interests and put them into a new organization to where the family, it's like a family trust or a family LLC, to where then those members of that organization are responsible for upkeep on the property and how it's going to be used. There's a lot involved there. The problem is it's really intensive and very expensive to get it done. So the longer it happens, the harder it is to undo it. So you try to nip this in the bud as soon as you can, because it's going to take more time, more research, more lawyers' fees to try to get it undone, to get the title into a good state, the longer that it happens. So for us in our clinic, the Generational Ancestral Property Clinic, we do help landowners to clear title. And of course, in the Oak Law Clinic, we can do a will. So we have clients who cross over between the two, trying to clear title to the property, also trying to get wills completed to make sure that it passes how it needs to the next generation. So we do both of those things. The one limitation that I'll just go ahead and mention to you now, because we get a lot of calls, by the way, and Danielle can attest to this. Let's see, is Adele here? Hey, Adele can attest to this too. You might want to say a few words about our clinic, but in terms of the cases that we've had, boy, the phone started ringing off the hook. We said, hey, we can help you with some heirs property. Guess what? Boom. We were getting blown up. And so to say like everything is heirs property is not really true. So we do limit our work to property that is 2 generations, at least 2 generations previous. In other words, if, let's say your mom or dad passed away, they had some land that was in their name and the deed is in their name, they pass it on to you. Maybe they got a will, maybe they don't have a will, but that's 1 generation there. We don't do those cases. We don't do those cases. What that requires is that you file the will for probate, or you go and you file for administration with the probate board of Montgomery County. The only cases that we take in our gap clinic are 2 generations or more. So we kind of limited it down there. But Adele, do you want to talk a little bit about our work before we adjourn for our lunch or Q&A? By the way, we're going to be around from now, and at least Adele and I will spend our lunch with you guys to see if you have individual questions. This is Adele Underwood. She's our staff attorney, mainly responsible for our gap clinic work.
Good morning, guys. Good morning. There's not much that has not already been said about what we do in the gap clinic. One of the main things that you need to know is that qualification, that it has to be 2nd generation or further back for us to assist you. But if anyone here has a heir property issue, or you have just specific questions, you're not sure if you have an heirs property issue, we'll be here through lunch to answer any questions that you might have. If you have any general questions, I can answer those for you now. But if you have something specific to your family's facts, I'd love to chat with you and see what we can help you with. But another thing to also note is we are not currently accepting new cases. You'd have to wait until July. If you do have an heirs property issue that we can assist you with, we wouldn't be able to provide assistance to you until July, which is this summer. That's all.
All right, so it looks like, where's Miss Neal? I think we're basically at break time, and then according to the agenda, lunches are supposed to arrive at around 11:30. So y'all take a break. We'll be hanging around if you have questions for us, and we've enjoyed the opportunity to speak with you today.